Hello everyone, I'm Anuj Jaggi and I'm a legal intern with LEXIS and Company. And the topic for today's second video presentation is Industrial Disputes and Resolution. So the Industrial Disputes Act of 1948, which now stands repealed by the Industrial Relations Code, was passed so to make provisions for the investigation and settlement of industrial disputes. The object of all labor legislations is to ensure fair wages and to prevent disputes so that production might not be adversely affected, also to maintain industrial peace. The Code 2020 also provides provisions for the investigations and settlement of industrial disputes. The Government of India is yet to notify the effective date of the code. The following adjudicatory mechanism has been provided under the Code: Industrial Tribunal, National Tribunal, Conciliation Officers, provisions for voluntary arbitrations, grievances redressal committee, works committee, etc. The code has removed the constitution of conciliation boards, labor courts, and court of inquiry, which was earlier provided for settlement under the Industrial Dispute Act. The principal objects of the Industrial Disputes Act, as analyzed by the Supreme Court in the Workmen of Dimakuchi Tea Estate versus Management of Dimakuchi Tea Estate, were that promotion of measures for securing amity and good relations between employer and workmen. Secondly, an investigation and settlement of industrial disputes between employers and employees. Next one is prevention of illegal strikes and lockouts, and relief or compensation in the matter of layoff or retrenchment, and collective bargaining. So the various important changes introduced by the Code of 2020 were definition of industry has changed and limited its scope. Second is definition of workmen. Industrial disputes changed, introduced the concept of fixed term employments. Next is grievance redressal committee was introduced. Constitution of industrial tribunal changed. Layoff retrenchment provisions limited introduced, and introduction of worker reskilling fund. So the term industry under the ID Act of 1948 was defined as industry means any business, trade, undertaking, manufacture, or calling of employers, and includes any calling of service, employment, handicraft, or industrial occupation of avocation of workmen. But the term industry defined under the IR Code of 2020 now includes industry means any systematic activity carried on by cooperation between an employer and worker, whether such worker is employed by such employer directly or by through any agency, for the production, supply, or distribution of goods and services with a view to satisfy human wants or wishes, whether or not any capital it has been invested for the purpose of carrying on such activity, or such activity is carried on with a motive to make any profit or any kind of gain. But this does not include that institutions owned or managed by organizations wholly or substantially engaged in charitable, social, or philanthropic services, any domestic services, or any other activity as may be notified by the central government. The definition of industry has not categorically excluded hospitals, agricultural operations, or educational institutions. Therefore, one might assume that they are deemed to be included in the Act. This may lead to cases arising as no express inclusion or exclusion of such bodies provided under the definition of industry. So this was the concept, or this was about the industrial disputes and resolution, and how the Act of 1948 has been repealed and now and stands by the Industrial Relations Code of 2020. So, thank you.